Good afternoon. Good morning. You can tell I've been up for a little while. My name is Anita Gaffney, and I'm the Executive Director at the Stratford Festival. Welcome to our penultimate forum event of our 2014 season. We've hosted more than 200 events over the last 6 months, everything from debates and panel discussions to concerts and comedy nights. The forum has been sponsored by some very generous donors, by Kelly and Michael Meighen, by Julian and Nandita Wise, by a gift made in memory of Dr. Phil Heyman, and today's event is sponsored by Guy and Mary Pratte. The 2014 marks Shakespeare's 450th birthday, so we've done a number of events through the forum to celebrate Shakespeare and to celebrate this landmark occasion. And we thought it would be fun to explore the authorship of Shakespeare's plays as part of the forum this year. The idea of debate springs very naturally from the works of Shakespeare's. He gives us situations that are very complex and layered, and it provokes discussion among audiences. And we hear that discussion at B&Bs and downtown and in our theaters, which is very exciting. And it has gained prominence lately through such popular films like Anonymous, and we're thrilled to have such keen minds turn their attention to this topic today. The size of the crowd today, which is fantastic here at the Festival Theatre, I think underscores the interest in this topic of the authorship of Shakespeare's plays. We're also joined by a home audience as well. Today's event is being live streamed to the festival's website, and it's also being taped by CBC Radio's Ideas for a Future Broadcast. We're going to start the event today with a cross-examination of William Shakespeare, the man from Stratford and the reputed writer of the Shakespearean canon. And he will be cross-examined by Guy Pratte, who is counsel for the Earl of Oxford. Guy is a partner at Borden, Ladner, and Gervais. Guy is a partner at Borden, Ladner, and Gervais. He serves on the festival's board of governors, and he has spearheaded the organization of today's event. Following the cross-examination, Sheila Block, who is on stage here with us, she'll be representing Shakespeare. Sheila is a partner at Tories, and she's back by popular demand after such a great turn last year at the Shylock Appeal. It is now my great pleasure to introduce our illustrious panel of judges. The panel is led by the Chief Justice of the Supreme Court, the Right Honourable Beverley McLachlin, 2 judges from the Court of Appeal of Ontario, the Honourable Robert Sharpe and the Honourable Eileen Galeese. And we're also joined by a very accomplished litigation lawyer, Tricia Jackson, who's a partner at Tories. And our final judge is Colm Feore, who stars in the acclaimed productions this year of The Beau Stratagem, which was on stage just last night, and also King Lear, which is on stage this afternoon. So we're very grateful to Colm to squeeze in this appearance in between his performances. So I would invite our judges panel to take their seats. And now I'd like to call to the stage the man from Stratford. For those of you familiar with the festival, you may recognize our bard beneath his beard and his pumpkin pants, but I'll let you figure out for yourselves who it is. And without further ado, we're very proud to present the Authorship Appeal.
I'm taking that if I stand. So you brought your fan club.
How did you get through jury selection? I'll never know. So, sir, I want to thank you first for traveling 400 years and from the depths of the undiscovered country. No jet lag?
It's 2014. I must have overslept.
Now, when you were first sworn in this court and examined in chief, you were asked to spell your name, and you spelled it thusly, Shakespeare, correct?
I think that's right. That seems to be the common variant these days. George Bernard Shaw tried to change it. He's a crackpot. It never caught on.
Now, can I show you something you claim to have been your will, actually? Would you identify that as Exhibit 1 and as being your will?
It seems to be what you call a copy. We could have really used this in those days. You just press a button. Yes, yes, it is.
Good. And could you confirm when you read through it that your signature appears 3 times and is never spelled in the way that you spelled your name when you swore an oath to the court?
Your time period seems to be obsessed with spelling. What happened to creativity?
Yeah. Well, if you were so creative, how is it that you never spelled your name in the way that you spelled it to the court this morning?
Well, I had a problem making up my mind. I wrote a play about that.
Is it true, sir? Are you comfortable? No. You shouldn't be. Then I'm doing fine. Is it also true that of the only 3 or 4 other documents that are authenticated and to bear your name, none of it is spelled the way you spelled your name to the court this morning? You can say yes,
correct.
that's okay. Thank you. And when one looks at your family records, is it not correct that your baptismal record, the records of your death, of your family tree, is never spelled Shakespeare the way you spelled it in court this morning when you were sworn in?
Well, I've never looked them up, but I'll take your word for it. You're an honorable man.
Thank you. I'll see if I can say the same when we're done. I even heard that you sometimes spell it Cimolino.
Busted.
Is that Shakespeare in Italian?
It's much better in Italian.
Yeah. Now, also earlier this morning, you told us that in 1623, there is a book called The First Folio was published, and by 2 of your alleged actor friends, John Hemminges and Harry Condell. Is that right?
That's correct.
And on that first folio as well, your name appears as Shakespeare, sometimes hyphenated, but never in the way you spell it in your will, which is Shakspere, correct?
Well, that was a choice that John and Henry made. Now, there are many different spellings of Hemmings and Condell, and of course, Christopher Marlowe is often called Christopher Morley, so it was a common thing.
I see. Well, we'll try their cases in due course after we're done with yours. But I just want you to clarify for the court that your best friends or your good friends never spelled your name in the way that you did yourself, right?
They made a choice.
Right. And similarly, of all the works that were published allegedly under your name since 1623 up to today, the name is always Shakespeare, not Shakespeare, right?
That may be the case. I haven't looked at all of the publishing since.
Maybe you should. Now, during your time, you were a most famous and celebrated playwright, probably the more famous of the age, right?
I bless you, thanks.
And you are said to have invented thousands of words and expressions that we still use today.
Yes.
Yeah. And you've never been to university, have you?
No. But neither had Ben Jonson. Robert Greene was a university playwright. He wrote a piece called Pandosto that I turned into something called The Winter's Tale. It was better.
Yeah. His or yours?
Mine, I'm afraid to say, yes.
Such modesty. And is there any record of your ever attending grammar school?
No, there isn't. But there was a grammar school in Stratford, and my father, as an alderman, would have had free tuition for his children. And there's no record of any of the students at that grammar school. It seems to have disappeared.
I see. Can you name anyone else who might have attended that grammar school who turned out to be a world genius other than yourself?
Knock 'em dead, Sheila. No.
And you claim to have written 154 sonnets, 37 plays, 2 long poems. I have a book here just to remind you, since you've traveled so far. So this is in very small print, something that's called The Complete Works of Shakespeare, spelled, of course, the way that you never spelled it. How much, presumably you wrote these in manuscript, did you?
Yes.
Yeah. And how much of that survives?
We don't have manuscripts. There's only one, which is contested, but it's a play called Sir Henry Moore, and there, Thomas More, rather. And of course, there are 6 different writers on that, and many scholars believe I have a page of that.
Right, but you don't even believe that yourself, do you?
I do. The writing's very good.
You'll do anything to win this case, won't you? There's no manuscript at all, and were there other writers, for example, like Ben Jonson, who left manuscripts of their plays, handwritten manuscripts?
Yes. Ben was a friend. I mentored him, but he was obsessed with posterity.
Oh. What's this festival called that we're in? What's it, the Stratford, in the store with all the memorabilia across the way? You call that modesty and not being obsessed with posterity? How much money do you make from that store, actually, by the way? Now,
I think there's a sale on.
In your alleged plays, there's an immense amount about the law, about Italy, about botany, and so I could go on forever. Where did you pick that up?
Well, you don't have to travel to a country to write about it. London would have been a small town, the writing community even smaller. John Florio, for instance, who translated Montaigne, where I borrowed Montaigne very liberally in my plays. John was an Italian Jew, and probably would have been somebody I would have spent lots of time with.
And did you actually read Montaigne yourself?
I would have read it from John's translation.
I see. And is there any record of your ever owning any books or borrowing any books from anybody?
There are no records of my having books.
Right.
But in this will, there would have probably been a separate attachment with the list of other chattels. I don't know about you, but in our time, the hourly rate for lawyers was very, very high. And I'm sure that's changed. And I wouldn't have listed everything, at least not by a lawyer's hand.
So just to get to the point, there is no record.
No.
Right. And the only records, there are about 70 records that relate to you, some by your own hand and other legal documents. All of them relate to lawsuits or business records. None are literary. Is that not right?
Well, I guess so. They would be the records that you would have, those that have survived.
Isn't that convenient that we don't have any other?
I like to maintain my mystery.
Well, there's a bit of a concession. So your friends who published the first folio allegedly, apparently misspelled your name, even though they were close friends. Were any of the plays in the first folio, like Macbeth, Measure for Measure, Titus, Andronicus, were they written by collaborators or with collaborators?
Well, collaboration was very common in those days, and 2 of the plays left out of the folio, Pericles and The Two Noble Kinsmen, perhaps Henry and John felt were too much of a collaboration to be written and published solely under my name. But it was common, and there might have been other sections of other plays. In those days, This romantic notion of authorship was not something we had. We were practical people in the theater. We needed to put on a show. Ego didn't enter into it, except for Ben Jonson.
Okay. So the name on the first folio is not your legal name, and the names of other co-writers does not appear, correct?
Correct.
Right. So there are at least 2 important inaccuracies in the first folio. Would you agree with that?
It was published after my death.
So the first folio, then you can't authenticate it or vouch for its accuracy, can you?
I was dead at the time.
Right. Amazing how you just came back to life now that you might be losing a case.
Popular demand.
Yeah. So let me show you something else from the first folio. You've had time in the last 400 years to take a look at it, have you? I'm going to show you an engraving. I'll show it to the court after I'm done. Just compare the hair.
I have this stapled on.
I see. Would you confirm for me that this is not your picture, is it?
It's a terrible picture.
Yeah. Well, let's take another one. This is something you sell like for 45 bucks or something. Look at this. Now, this was thus purchased. It should be more accurate. It doesn't look like you, does it?
Well, it's, he's got a higher, more intellectual hairline.
Yes. It's okay. You can actually agree that.
Yes, it
Yeah.
does not look
Okay.
like it.
So if we were to sum it up, the document, the first folio, that is relied upon probably most than any other document, it doesn't spell your name correctly, doesn't have your picture on it, and is inaccurate in the sense that it doesn't even acknowledge other writers. Is that not right?
That would be correct.
Right. So would you at least go this far with me, sir, based on what we've discussed, that there's at least room for doubt as to whether or not the man from Stratford actually is the author Shakespeare?
Mr. Pratte, that will be for the court to decide.
Thank you, sir.
Very well. She does this at the Supreme Court, too. She's always talking to somebody else. Chief Justice, Justices, may it please the court. There's no need for a re-examination after that performance by the witness. I will be calling expert evidence establishing when spell check was created. Let me start where the law starts, with eyewitnesses. Numerous comments from contemporaries about Shakespeare as author and actor abound from fellow writers and people in the theater, people like Green, Marys, Haywood, Webster, Marston, Weaver, Decker, names that mean nothing to us, but they all knew him and saw him in action. But the best eyewitness is the rival dramatist Ben Jonson, as my client has affirmed. I say he's the best because he had no problem putting Will down, criticizing his lack of knowledge of geography, recording in his diary that when his actors praised him for not blotting lines, i.e. not making corrections, he famously quipped, "Would that he had blotted 1,000 lines." The interesting thing about our witness Jonson is that he was described by the observant poet, Scottish poet William Drummond, who lived with him for a year. He said old Ben was a great lover and praiser of himself, a contemner and scorner of others, much as you heard from the witness. Well, consider what this narcissistic contemner and scorner of others said about his chief rival in the dramatist category. He said, "I love the man and do honor his memory on this side of idolatry as much as any. He was indeed honest, had excellent fancy, brave notions, gentle expressions." And Jonson, as you know, also wrote a memorial poem that was published with the first folio edition of the 36 plays, entitled "To the Memory of My Beloved, the Author, Mr. William Shakespeare, and What He Hath Left Us." In that poem, he called him the sweet swan of Avon. Now, this evidence linked to Shakespeare and linked to Shakespeare writing the 36 plays by yet another person who knew him and saw him in action is, in my respectful submission, conclusive. In the law, we talk about witnesses who have no motive to misrepresent. Well, here Johnson would have had a motive to run down his rival. So when we have this evidence from a contemporary, a competitor, who liked to think of himself as the cock of the walk, it is all the more credible. And also there is no evidence for anyone else, no documents, no other contenders. Indeed, the idea that it was someone other than Shakespeare didn't even first surface till 1856. And my friend's client, my learned friend's client, didn't come up until the 1920s. The second point I want to address are these "it couldn't have been Shakespeare because" points. He wasn't a lawyer, yet showed knowledge of the law. Well, the first point, you should have been here last year. This courtroom scene from The Merchant of Venice was just one charter violation after another. And I'm still waiting, Chief Justice, for the decision vindicating my client Shylock, and he's not getting any younger either. But in this case, the point is that Will lived in an era of legalisms and litigiousness. It was widespread, and one thing we know about Mr. Shakespeare is that he sued and was sued. He loved that stuff. And every lawyer in this auditorium knows. They've all had clients like this guy. They're not lawyers, but they think they know the law. And if we're going to bother with facts, let me direct you to a text from 1913 by J.M. Robertson entitled The Baconian Heresy, in which he devotes 200 pages to showing that legalisms pervaded Elizabethan and Jacobean literature, and litigiousness was a popular pastime, much like class actions today. Writers in and around Shakespeare's era, like Greene, Chapman, Johnson, Dekker, Heywood, all outdid old Will when it came to extended passages of legal jargon. Well, it couldn't be Will because he never went to Italy. Well, Frank Herbert never went to Dune, Ursula Le Guin never went to an intergalactic airport lounge, and Tolkien never went to Middle-earth. He probably didn't even go to New Zealand. Besides, geography was not Will's long suit. He put a sea coast and a desert in Bohemia in The Winter's Tale. He had Prospero sailing from Milan to the Adriatic in The Tempest, and he has a sailmaker living in landlocked Bergamo in The Taming of the Shrew. In fact, these points are corroborative of the fact that the writer hadn't been to Italy. And of course, Oxford had lived in Italy, spent 7 years there or something, and he wouldn't have made these mistakes. Couldn't be Shakespeare because Shakespeare's too good. And besides, they say, look at all the clever people who say it couldn't have been Shakespeare. Helen Keller, Mark Twain, Emerson, Dickens, Henry James, Sigmund Freud. But this is just people's opinions, eminent as they may be. And it's driven by the notion that Shakespeare is amazing and timeless. And he is. Where is Shakespeare? He was one. But the thing is, there are a whole lot of people who are very clever who take quite the opposite view and have lobbed insults and derisions at the Bard of Avon. Charles Darwin said he found Shakespeare so intolerably dull it nauseated me. The poet Walter Savage Landor, who was a character in Bleak House, by the way, and was a mentor to Yeats and inspired Yeats and Frost and Pound, he said, the sonnets are hot and pothery. Pothery is a 7-letter word, very good in Scrabble. And it means humid, muggy, and stuffy. Voltaire referred to his work as this enormous dunghill. Tolstoy called him crude, immoral, vulgar, senseless. And finally, George Bernard Shaw, who has already been mentioned, said this most earnestly, with the single exception of Homer, there is no eminent writer, not even Sir Walter Scott, whom I can despise so entirely as I despise Shakespeare. He said the intensity of his feelings was such that, quote, "It would be positively a relief to me to dig him up and throw stones at him, knowing as I do how incapable he and his worshippers are of understanding any less obvious form of insult." Now that's an insult. It's a downright Shakespearean insult, by the way. No wonder GBS hauled off to down the road to Niagara-on-the-Lake, lest anyone think he would have had anything to do with this lowbrow hack here at Stratford. So the very premise that these plays couldn't have been written by the Glover's son from a provincial backwater is hotly contested by those who think, in fact, the glove fits. Speaking of insults, Shakespeare could toss them about with the best of them. Best of lowlifes. This is another corroborative point because the deniers say, well, it had to be nobility, it had to be royalty, it had to be a highbrow. But, for example, Prince Hal used to Falstaff, "Thou clay-brained guts, thou naughty-pated fool, thou obscene greasy tallow catch." Richard of York was described as a heap of wrath, foul, indigested lump. This afternoon we're going to hear "thou whoreson Zed, thou unnecessary letter" in Lear, and a whoreson beetle-headed, flap-eared knave in Taming of the Shrew. And as the editor of the Royal Shakespeare Complete Works of Shakespeare, Eloise Seneschal says, quote, "The plays are absolutely packed with filth." He had 100 different words, I don't know if there are children in the audience, for a female body part that I will not mention. Indeed, there have been vigorous movements over the years to eradicate the smut from the bard's timeless prose. In fact, the word bowdlerize comes from Thomas Bowdler, who was a Scottish straight-laced doctor who revised the work to rid them of all the indecencies. Luckily for us, that movement has never really taken off, and we're only left with the word bowdlerized, which is too long for Scrabble, by the way. And directors like Antoni Cimolino delight in adding suggestive gestures to the lowbrow prose that one finds in every play. So for those who say Will was too ordinary, too low class, too lowbrow, too humble, I say res ipsa loquitur. They all know what it means. It means the thing speaks for itself. The lofty rival candidates, like the Earl of Oxford, Francis Bacon, didn't knock about with lowlifes like actors and couldn't possibly fill the glossary of classical smut that Will managed to import into every single play. But they say we know so little about Shakespeare's life. But extensive biographies of writers of those days are non-existent. Indeed, Richard Hathaway, who was one of the best comedy writers, wrote 18 plays, and his plays didn't even survive. As Time magazine editor Howard Schwa said, and it applies not just to Shakespeare, but everyone of his era and for eras thereafter, Shakespeare is a man about whom it is impossible to write the literary biography as we know it today. Kiss, tell, stab in the back, keep the copies, and don't dry clean the doublet. That just wasn't the style then. In today's world, we know more than we ever want to know about the Kardashians, whoever they are, and Paris Hilton, and they haven't written a bloody thing. But it doesn't mean we don't know anything about our eminent author. There's a very learned tome. Gale's Dictionary of Literary Biography, with all the books my friend brings. He doesn't bring this one. Unfortunately, you don't get to the William Shakespeare Life Records volume until volume 263. It's written by Catherine Loomis. And very few people have gotten that far because you have to buy the other 262 before you get to 263. But she has 300 documents, pages of documents connected with Shakespeare, his family, the theatrical troupes he was in, and the various lawsuits and transcripts. And there are connections with the bard and his plays. Let me give you 7 facts and then I will sit. First, he had a son named Hamnet, who tragically died young. Go back and read the moving speech by Constance in King John. Grief fills the room up of my absent child, lies in his bed, walks up and down with me, puts on his pretty looks, repeats his words, remembers me of all his gracious parts, stuffs out his vacant garments with his form. Shakespeare knew grief. Second, there was a drowning in the Avon River, 1569, could have inspired Ophelia. The Taming of the Shrew, number 3, has reference to the standard Latin grammar used at the Stratford Free School, where Will's father, as an official, as he said, would have gotten tuition remission. Fourth, the education at the free school was relentless, 6 a.m. to 6 p.m., classical rhetoric, oratory, letter writing, Latin and Greek, including the plays, so Virgil, Ovid, Horace, history, maybe not a lot of geography. In 1575, and this one I think is really interesting. You have to draw an inference, which I know you're capable of doing. When Will was 11, there was an enormous entertainment, just basically around the corner. The Earl of Leicester was putting on 19 days of presentations and entertainment for the Virgin Queen. And as a local official, Father Shakespeare probably took son Will there, and that could have made a profound impression. 6, in Measure for Measure, Claudio was jailed for impregnating an unmarried woman. Well, Shakespeare wed the pregnant Anne Hathaway, as we all know, who was 8 years his senior. And finally, Oxford died in 1604. Shakespeare continued to write for another decade with partners who would have been able to tell the difference between the dead Earl of Oxford and their friend William Shakespeare. Macbeth and The Tempest were inspired by real-life events written after 1604. Macbeth, which is dated 1606, references the gunpowder plot in 1605, the great equivocator, Henry Garnet. The Tempest, inspired by George Somers' misadventures in Bermuda in 1609 when a hurricane hit the Virginia, and the fleet was ultimately discovered, but at the time thought was lost, and there were 400 colonists on board, and Shakespeare knew a number of them. But one last point. De Vere's poems, have you ever read those? Dull, devoid of depth, for example, this timeless phrase, framed in the front of forlorn hope past all recovery, I stayless stand to abide the shock of shame and infamy. That's his client's effort. Anyway, there's an enormous expenditure of time, resources, persistence, intelligence. You'd think as a result we'd have gender equity or world peace. Hold it, those are the same things. The amazing man who wrote an average of 2 plays a year, who speaks to us more than 400 years later, should be allowed to rest in peace. And no one should take his identity or legacy away from him. Those are my submissions. Thank you.
That's gin. May it please the court, it's a true honor to appear before this court, and I must say before Ms. Block, I'm delighted that Shakespeare made so much money during his lifetime that he could now afford her services. Now, I have to concede that she made some good points. If you assume that relying on 400-year-old hearsay from the likes of Ben Jonson, who was known as the master of equivocation, should count as admissible evidence in a court of law. It's interesting, actually, that she defends Shakespeare's knowledge of Italy, for example, that it was full of inaccuracies. And at the same time, she asks us to rely on his evidence in court and other historical facts, like the flood and the storms that she referred to. Now, I realize that raising some doubt as to whether or not the man from Stratford actually wrote the plays in this hall in the city of Stratford may be somewhat uncomfortable for some people here and may be difficult to accept, must be particularly jarring for my Lord Feore, playing King Lear, no longer certain of who fathered him in the end. But courts of law, like the arts and the theater, exist to put our most profound convictions about facts and reality, whether those should be religion, historical facts, scientific facts, on trial to question and reassess our preconceptions. We hold many truths to be self-evident without ever really having given them much thought, and yet we hold on to them for dear life. We have heated debates with our friends and colleagues and defend our views earnestly, when in fact we are often betraying some preconceived opinion or prejudice, not rooted in a prior objective assessment of the evidence. That is true not only in science, it's also true in literature. We go to university or maybe high school and we read the Iliad or the Odyssey. And the book upon which we find those long poems says that Homer wrote those. In fact, there's basically no evidence whatsoever that Homer ever existed, at least tied to those long poems, and there's in fact a whole debate as to whether or not a single person wrote those. Consider now a more modern example. You go to Chapters and you buy a book, has the picture of Sarah Palin on it. And it says, written by Sarah Palin. I mean, who believes that she wrote the entire book? The fact is, as the saying goes, that you cannot judge a book by its cover. The book, the first folio, misspells Shakespeare's name. Now we say, well, we didn't have spell check. You'd think the greatest writer in history would be able, sometime in his lifetime, to spell his name correctly. The engraving on the front, the equivalent of the Sarah Palin, is not of him. He admitted that. The name we use for him is never the name he used. So I say the real issue in this case, much more fundamental than who wrote the canon, is this. The real question is whether we're prepared to set aside, if only for a few minutes, our own strongly held convictions or assumptions in order to subject them to the scrutiny required in a court of law. Assume for a moment, just a moment, that we don't know who actually wrote those plays, and we try to assess the evidence to see whether or not it is foolish to claim that there might be some doubt about that. So let's look at the evidence. It's said that we know a lot more about Shakespeare than we know about any writer of his time. But none of the facts that we really know about him actually point to a writer. All the documents, church records, his own will, his own business records, court records, never ever relate to any literary business, none whatsoever. They relate to lawsuits to protect the hoarding of the grain, his money lending, and so on. It's very odd that not a single record that remains is connected to a writer. There's no manuscript in his own hand, no record that he ever claimed when he lived that he was a writer. No record by any family member ever claimed that he was a writer. No writer or fellow actor writing in his own time when he was alive ever claimed he was an actor. By contrast, Johnson, apparently a lesser writer, left books, manuscripts, a literary correspondence, and you can do the research, you'll find that of the 25 or so writers of the time, the vast majority of them left contemporaneous evidence proving that they were writers. His appearance. One of the authors that, I call them the apologists for the claim that Shakespeare of Stratford was Shakespeare, writes about the appearance of Shakespeare. This is Bryson, quote, "The paradoxical consequence is that we all recognize a likeness of Shakespeare the instant we see one, and yet we don't really know what he looked like." So the usual and most reliable means of settling issues of identity is totally useless here. Now, what about his name? I've gone into that already. Bryson also says he did not use the one now universally attached to his name. That is hard fact. And as I said, the spelling of his name as we now know it is never used in any contemporary evidence. Now, biographers, like the ones my friend relies on, like the Shapiro book she has there, Contested Will, hidden under the Shakespeare quotation books, blithely skip over that. Now, if you think that just a difference of 1 or 2 letters doesn't make any difference, let me give you a couple of anecdotes. I'm reliably told that someone one time phoned a restaurant in Vancouver to make a reservation for Ms. McLachlin. The restaurateur, having spelled the last syllable L-A-N as opposed to L-I-N, was much surprised when the Chief Justice showed up at the door rather than the singer, Sarah McLachlan. And Justice Sharpe, spelled without an E at the end, would still be a Sharpe, but he wouldn't be sitting there. Take Churchill, once seated beside I. Berlin at a fancy dinner that he thought he knew, asked him, "What is your most famous writing?" His guest, to his side, replied, "White Christmas." Churchill thought he was seated beside the philosopher and historian Isaiah Berlin. It turned out to be Irving Berlin. No manuscript. The most prolific writer in the world left authenticated documents, but not a letter. He spent his entire life, most of his life had to be spent writing, and nothing survives. Then I want to come probably to the strongest argument my friend has made. The plays and the poems tell you something and equate and connect it to Stratford. Now, the author she relies on, Shapiro, in Contested Will, says this about trying to draw any inference from the plays and the poems and try to connect that to the man from Stratford. He says, and I quote, "This sort of speculation has become commonplace in popular biography of Shakespeare. The more that Shakespeare scholars encourage autobiographical readings of the plays and poems, the more they legitimate assumptions that underlie the claims of all those who dismiss the idea that Shakespeare wrote all of the plays." That's at page 266 and 67 of your little book, Ms. Block. It is wiser to accept that these experiences can no longer be recovered. We don't know what we are looking for in any case, and even if we did, I'm not at all sure that we would know how to interpret them. In the end, attempts to identify personal experiences will only result in acts of self-projection, revealing more about the biographer than Shakespeare himself. Are there unknowns? I've talked about them. I won't go over that. But one thing I'd failed to mention, when Shakespeare, allegedly the most famous playwright who had been in the palaces, had his theater company perform countless times before Queen Elizabeth and King James, no notice upon his death, absolutely nothing, like Ben Jonson and others. So in the end, we're left with speculation. If you read the Contested Will, replete with such expressions, you will find that treatise. We can be pretty sure it's more likely that they must have known, and so on. When you consider the meager facts that are real evidence, does this evidence really lead you inexorably to the conclusion that such a person from an illiterate family with a different name, only known for certain to have been a business person and sometime actor, must in all likelihood have been the man who wrote the canon? If Shakespeare were ever sued for libel or treason, he'd have a very good case for mistaken identity, I submit. Now, Ms. Block, and I'll come to my conclusion now, insists that the claim of her client is stronger than any other candidate. And she insists that the issue really is, in the end, who of the known candidates has the best claim. But as to assume that we can and must identify the author more than 400 years removed, perhaps the only reasonable answer is we can't. If you look at the strongest proponents of Shakespeare, Stratford being Shakespeare, the Birthplace Trust, which has a very fancy website, you will read at page 20, that's in the court's material, the great scholar Wilson, author of a book on Marlowe and Shakespeare, once said that the most important thing a scholar has to learn is to say, "I don't know. I don't know." Wish that they'd taken their own advice. So, my plea to this court and to this audience is, in fact, very modest. I don't ask that my client, De Vere, for whom I actually act pro bono, by the way, be found to be the author of the canon as opposed to William Shakespeare of Stratford upon Avon. I only ask that you, members of the court and of the jury, who are here for free, remember that, set aside whatever idea of authorship you may have had when you walked into these hallowed halls, and that you assess the claim on behalf of Shakespeare of Stratford based on evidence, not speculation. If I have persuaded you only to do that, I would have succeeded in my real mission, which is to remind you that courts, like the theater, should be places where we can question our most profound beliefs. The progress of humanity, the hope for a better world, depends on that willingness, for as the philosopher said, the unexamined life is not worth living. And that brings me to what really matters. As someone, I don't think we'll ever know who, famously wrote, "The play's the thing." Thank you.
Ordinarily, the court would reserve on such a weighty matter as this, and it may be in the end that we will be obliged to do so. However, I am calling on my colleagues on the bench to deliver such wisdom as they may have at this time. We will begin with Justice Jackson.
Thank you, Chief Justice. I do this with some trepidation, being the one person up here with no judicial experience and effectively not the knowledge of Shakespeare of others on the bench. So these are preliminary observations only. But it does seem to me that this is a case which well illustrates the principle that the absence of evidence is not the same as the evidence of absence. And that in this case, that proposition is brought forward in spades because we're looking at events that happened more than 400 years ago, when there were no records, and such records as there were fewer records by far than we have today. And 400 years, in the 400 intervening years, most of the witnesses, except perhaps one, have died, and many of the records have disappeared. It seems to me the case has some parallels with cases that I am familiar with, having to do with plagiarism in universities, of which there are many these years, and they all have with them attendant a huge body of records and data, electronic essays, electronic searches. You can run it through turnitin.com, and you can get a lot of documentary information. But the experience is that even when you have that raft of evidence, at the end of the day, there are gaps in that evidence that you don't know about until you hear from the witnesses, or there are explanations or context that you don't know of until you hear from the witnesses. And here we have very few records, almost none, and only one witness who it was in fact a miraculous attendance we had here today. And I suppose one might say that the force and creativity of Shakespeare's intellect might be demonstrated by the fact that he was able to transcend 400 years and occupy the mind and body of the artistic director of the Stratford Festival. But in fairness to Mr. Test, his recollection, or of any other of the relevant contenders. So it does seem to me that for a court of law to resolve this question 400 years later is perhaps unfair. I can't see anything over there, Mr. Pratte, and in any event, I think it's too late. I think it's likely that what we've seen here raises many important questions for the historians to continue to debate. But I'm not sure that they are questions that can be resolved today by what I am pleased on this one occasion to call mere judges. We must be governed, because I'm the only one up here who is part of the cooperative insurance plan that also insures Mr. Pratte and Ms. Block. And the one thing that is clearly actionable negligence for a lawyer is to miss a limitation period. But in Ontario, we have an ultimate limitation period of 15 years. And I think this case is over 300 years too late.
I call on Justice Sharpe.
Thank you, Chief Justice. I, too, will reserve my judgment, but I would like to say that, for me, the brilliance of the oral arguments we've heard, the cut and thrust of Antoni Cimolini's tough cross-examination remind me, and I think remind all of us, how much the theater has in common with the courtroom and how much the courtroom has in common with the theater. We have witnessed here today the high drama of adversarial justice, the clash of opposing views laced with eloquence, wit, and humor. The lawyers' questions and arguments were as carefully crafted as the lines of the play that will be performed here this afternoon. And of course, lawyers, like actors, play a role, the role they're assigned by the adversary system. They strive mightily to convince us of the justice of their client's cause, but like the actors who play on this stage, they never really tell us what they think. We don't know if Sheila Block believes that Shakespeare did write the plays. We don't know if Guy Pratte thinks he does not.
No, he doesn't.
But from their well-executed adversarial role playing, I think we've all gained a clearer picture of the authorship debate, just as those of us who return here this afternoon to see my brother Judge Feore assume his assigned role as Lear will all gain a deeper appreciation of old age, madness, and tormented parenthood. It can be no accident that Shakespeare, or was it someone else, mentions lawyers more than any other profession. And as actors, as the bard, whoever he may have been, said, do as adversaries in law, strive mightily, but eat and drink as friends. And certainly it is in the adversarial battles of the courtroom that we see the truth of this observation. All the world's a stage, all the men and women merely players. They have their exits and their entrances, and one man in his time plays many parts. I actually never thought I'd get to say that on this stage. So while I refrain from using my judicial office to pronounce upon the issue of authorship, I say that whoever it was who did write the plays would surely rejoice in this gathering of lawyers, judges, actors, and theater lovers celebrating all that we have in common.
Justice Feore.
Thank you, Chief Justice. I am perhaps slightly more prejudiced, but I will reserve in this case. However, I would like to point out some fundamentals that may change one's view of this. And the first is that Shakespeare had no interest in being seen as a writer. He was a theater professional. He was in it, as many of us are, for the money. He showed no interest in publishing the plays. He created them merely as a way and a means to retire in luxury to Stratford, which he did the moment he could. They were seen not as literary artifacts, but as blueprints for actors. Nothing more, nothing less. As to the inability for us to say, well, here, poor Glover's son could not possibly have left these works of such towering genius, I offer a contemporary example of a plumber's son born in Belfast who had a talent and nurtured that talent and was encouraged, grew and prospered, loved Shakespeare, thought he might start a theater company, played a few kings, thought he might find a patron, reached out, secured, and sought the help of royalty, and found it. And Prince Charles became patron of the Renaissance Theater Company and helped someone who I think has done more for Shakespeare than almost anyone else, whom we now know as Sir Kenneth Branagh. So a plumber's son from Belfast did all right for himself. I would venture to say he probably has his own coat of arms that Shakespeare got, looking in his litigious way to legitimize his family name and his history, but not his literary legacy, a thing he cared not a whit about.
Justice Scalise.
Chief Justice, this is really rotten on your part. I have to come after Justice Colm Feore. Really. And who comes after me? The Chief Justice of the country. A completely daunting task. Nonetheless, I thank you, Chief Justice. The work attributed to Shakespeare has had such a profound impact on the English language. And as you'll see, I've drawn heavily on that work in my remarks. So, for example, it was said that brevity is the soul of wit, But as I have been legally trained, I will completely ignore the good common sense that underlies that. Instead, I will use all that legal jargon to make my remarks as obtuse as necessary so that you can rise as one and declare it is all Greek to me. May I begin by commending counsel, Mr. Guy Pratte and Ms. Sheila Block, for their brilliant performances. Like my brother Sharpe, those performances lead me to wonder whether all the world is a court and all the men and women surely lawyers. And if that's not a frightening thought, what is? But if nothing else, these able advocates have persuaded me that the case, both for and against Shakespeare's authorship, is full of sound and fury, signifying nothing. In short, it is precisely the type of case, Chief Justice, which this court should be hearing and deciding. Let us consider then the question for which this court has been convened today. Is there sufficient evidence to refute the claim that Shakespeare was the principal author of the canon? Certainly, the result is not a foregone conclusion. However, rather than answering the question before the court, I will play fast and loose with it and transform it into a question that I would like to answer. To this end, may I suggest that the real question raised by this case is, what's in a name? Would Shakespeare's plays by any other name sound as sweet? Or perhaps the true question is whether Shakespeare, whomever he was, had to his own self been true. Alternatively, yes, they are corny. Alternatively, we might consider whether Shakespeare was more sinned against than sinning. If we were to pursue the question of what is in a name, I query the persuasive value of the case put forward by Mr. Pratte. As I understand it, during the centuries in which this debate has raged, over 80 names have been presented as candidates for the authorship of Shakespeare's works. Now, I am familiar with the tactic of presenting one's case in the alternative, but frankly, Mr. Pratte, I found this to be too much of a good thing. Is not the prosecution of this case severely undermined by having failed to present a coherent theory of who wrote the plays, if not Shakespeare? No sooner is one possible candidate disqualified than another is suggested as a replacement. A wise man once said that nothing will come of nothing, but in my respectful opinion, nothing will come of throwing in the kitchen sink either, Mr. Pratte. Further, I would draw an adverse inference from the extreme delay in the prosecution of this case. Those calling into question Shakespeare's authorship first made public their theories in the 1850s, more than 200 years after Shakespeare's death. I also place significant weight on the fact that those advancing the case against Shakespeare failed to call the evidence of any of Shakespeare's contemporaries, and that none of the people who knew Shakespeare personally testified against him. Now, the long and the short of it is that difficulties in bringing such evidence before the court is no excuse and does nothing to undermine the seriousness of these omissions. In the same vein, I find it troubling that the prosecution delayed in bringing the case to the courts until Shakespeare himself was no longer able to defend himself. Like my sister, Justice Jackson, I am delighted by the miracle that enabled Shakespeare to join us today. His presentation and performance under cross-examination was formidable and leads to a powerful inference against the prosecution. Now, the fact that Shakespeare never bore a striking similarity to Stratford's own Antoni Cimolino is not something we should hold against Shakespeare. On the other hand, I do agree that the respondent supporters of Shakespeare, as so ably represented by Ms. Block, have not always done justice to their own cause. The respondents' long-standing failure or inability to recognize the likelihood that Shakespeare collaborated extensively with other authors undermines their position and casts doubt on the credibility of their witnesses. Furthermore, the respondents really must confront the inferences to be drawn from Shakespeare's character and background. A voir dire should have been held to determine how much of that character evidence was properly admissible. In any event, having admitted the evidence, I find it of little use. Does the fact that Shakespeare was a commoner and a moneylender and an
avaricious hoarder of grain mean that he was incapable of imagining the worlds created within his plays. Some might observe that those attributes made him fit for all kinds of lofty positions, some of which are in evidence here today. That was a dangerous move, really. Career-limiting, very career-limiting. On the matter of Shakespeare's character, I would simply observe that as a judge, I am familiar with the infinite variety of human creativity, although I often find it put to more tawdry purposes, and I applaud Shakespeare, whomever he was, for putting his imagination to such good use rather than turning to a life of crime. So where does that leave us then on the question of Shakespeare's authorship? If after hearing my remarks thus far you still have no inkling as to how I would decide this case, I'm not surprised. I've often found that my own train of thought has vanished into thin air. Legal trick. Moreover, I have to say, though, I find it difficult to decide a case wherein I'm unable to discern its true nature. Is the case before the court today a civil case, or is it a criminal case? As good luck would have it, it matters not. If this is a civil case, regardless of what limitation period applies, that period has been passed, and accordingly, I would decline to decide the matter. If, on the other hand, this is a criminal case, then I accept the submissions on behalf of the respondent that flagrant charter violations lead me to conclude that the charges should be stayed. The lapse of time between depth and prosecution of this case leads me to ask, 11B or not 11B? That is the question. Should this court, I think that was a sign, eh? Should this court suffer the slings and arrows of outrageous delays or take guidance from our charter and by staying the case, end it? I conclude that this trial does in fact violate Shakespeare's charter-protected right to be tried within a reasonable time. Accordingly, even if this is a criminal prosecution, I would stay the charges and therefore never be required to decide this vexed question, trusting that the truth will out in the end. I would, in conclusion, say this. I would be completely remiss if I did nothing to instigate further litigation. Thus, I conclude by querying whether in the midst of all this pomp and ceremony there may lie a suit for malicious prosecution. You may well respond by saying that's what's done cannot be undone, but that has never prevented anyone from taking a matter to the courts. Thank you.
Well, I want to begin by thanking my colleagues for their conclusions, unhelpful as they may be. A second preliminary comment which I wish to make is to tell the audience here, to reassure them that all of us on this bench feel a profound and heavy responsibility today. We're used to dealing with heavy responsibilities. Indeed, it is said that my job on the Supreme Court of Canada requires my colleagues and I to decide some of the most burning and pivotal issues of the day. But as a judge of the Supreme Court of Stratford, I feel a weight immensely greater. This has been abetted by the fact that in the past weeks, since the announcement of this trial has gained currency, I have been the recipient of a great number of ex parte submissions. My favorite came from a gentleman in Temiskaming who said, "I am so glad that you have taken this question on. Finally, it will be resolved." Now, it is my custom in situations such as this to listen to my learned colleagues and then say, I came, I saw, I concurred. Alas, today my colleagues have not left me with that option. So let me briefly look at the evidence for and against the proposition. The evidence for the case that Shakespeare did not himself pen the great plays and the sonnets attributed to him is based on several, what I would say are rather dubious arguments, with great respect to Mr. Pratte. It is said that the person who wrote the plays and sonnets could not have come from a small town with an ordinary grammar school. Well, we all know that judges are impartial, objective, and disinterested. But I must confess to you that sometimes judges let their personal experience color their conclusions. So this argument put me back. I come from a very small town, Pincher Creek, Alberta, lost in the foothills. And the fact that Warren Winkler also came from that town doesn't make it any better. I had a very, one would say, with the 400 or 500 years later, I'm sure, a mediocre education. I had nothing going for me. But all of this puts into question where I am. Am I really a judge on the Supreme Court of Canada? Am I really, could I be Chief Justice? No, women never held such a role. So I must admit, brilliant as your eloquence was on that point, I find, Mr. Pratte, that I have the slightest doubt. Now, a second argument Mr. Pratte puts is that the person who wrote the plays and sonnets could not have been William Shakespeare because he didn't know how to spell his name. Well, again, continuing in the personal vein, just last night at dinner, a dinner sponsored by people associated with this event, I looked at my name card and it said Beverly, misspelled. And as Mr. Pratte, in fairness, has pointed out, I have occasionally been mistaken for many other McLachlins. My name has been spelled in many different ways. In fact, I've counted 13 to date, and very often in the very factums which counsel file, in which they are pleading with me and my colleagues to find in their favor. So I must discount this argument. Finally, there is the hair argument. Now, it is said that Shakespeare's hair has somehow magically reappeared in the course of 400 years. That Shakespeare was actually rather a pointy-chinned, bald-headed man, whereas Mr. Cimolino, our actor here today, well, we know the elegance of his face, of his physique. Clearly, this cannot, it is said, be the true Shakespeare. But on the hair again, my personal reflection leads me to a different conclusion. When I had my 20th anniversary on the Supreme Court of Canada, my then colleague, Ian Binney, who will be known to some of you, now you didn't know he was a cinematographer, but he did on this occasion produce a film for the entertainment of my colleagues and the assembled court staff, which shall remain private. I've put a sealing order on it. And in the film, Justice Binney, as he then was, in his most persuasive way, made the case that in the course of 20 years, I had had 20 different hairdos. So, Mr. Pratte, again, with the greatest respect, I retain some doubt. Now, in the end, despite your brilliant arguments, I think what you said in conclusion is where we must end. We must all have doubt. And so I take my refuge in that great solace of the judge, which is the burden of proof. We have a presumption in this case, a presumption confirmed by many centuries of erudition, that Shakespeare, William Shakespeare of Stratford-on-Avon, was the author of the plays attributed to him and the sonnets. It is the burden, regrettably, on Mr. Pratte and his client to rebut that presumption. And I must, like my colleagues, find that the evidence remains unclear. In that circumstance, the presumption is not rebutted. It is a case not unlike an early case I had when I was a trial judge, when I put a difficult point to counsel, and he stood up and said, "Well, Your Honor, there are the pros and cons for it and the pros and cons against it." So, saddened as I am, and I do hope that my friend who is counting on this court to resolve this question once and for all will forgive me, I take my refuge, my final refuge, in the words of a great jurist, Oliver Wendell Holmes. He said this: "Certainty is an illusion, and repose is not the destiny of man, nor, sadly, it seems, of women." I cannot conclude without a word of thanks, first to Mr. Cimolino for giving us the rare chance to meet Shakespeare, or whoever he is, in person. I want to thank our counsel, Mr. Pratte, Ms. Block, who did a superb job. Their sense of humor, their humanity, and their erudition shone through and entertained all of us enormously. I want to thank our judges, Tricia Jackson, Robert Sharpe, Colm Feore, Eileen Gillese. Even if they did disappoint, they demonstrated for you all the judicial evasions possible. Refuge in the statute of limitations, refuge, with due deference to Justice Sharpe, in the ethereal realms of philosophy. Reference to, "I can't decide, but here's what I really think," Justice Feore. And again, with Justice Gillese, lots of philosophy. She started off by saying she wouldn't answer the question put. How many times have we done that, we judges? So you had a bit of a demonstration of how judges sometimes think as well. And I thank our panel for that. And I want to conclude by thanking you, ladies and gentlemen of the audience. Without you, there could be no trial. Without you, there could be no show. As William Shakespeare, or someone, said in As You Like It, Act 1, Scene 2, "The little foolery that wise men have makes a great show." We here today are all wise people, and I think we have had a great show with our little foolery. Thank you.
Thank you. I'd just like to conclude by thanking the Chief Justice Beverley McLachlin. As I said at the beginning of my remarks, this is our second to last forum event. Our last forum event is on October 18th in Toronto at the Isabel Bader Theatre. We're collaborating with the La Fontaine Baldwin Symposium and presenting Robert Lepage as our keynote speaker, and his speech will be followed by some roundtable discussions so that the discussion can continue. And of course, we'll be back next year with the forum in April of 2015 on the theme of discovery and that eureka moment. And if there's moments during the winter that you're feeling unfulfilled and you want to react to some great forum events, please visit our website and take in today's event that we've live streamed and also a number of other events that we've live streamed throughout the season. Thank you for joining us today, and thank you to all of our participants in today's appeal. Thank you.